Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt here on 9:30 a.m. The Answer. Also on podcasts, Facebook, YouTube. So follow me, subscribe, and you can get notifications on when we post new content. The reason that I do this radio and podcast is because God had one rule: don't eat from the fruit of that tree. Then we had the 10 Commandments, and now we have municipal, state, federal lawmakers that won't stop making new laws. So I wanted to ask you, Judge, have you seen that movie, The 10 Commandments?
Yes, I have. Yes, that's a classic.
Did you know that who do you think, or who do you remember produced, directed, and narrated that movie in 1956?
I remember Moses was a very larger-than-life big character. It was one of those films I saw when I was very, very young. Mm-hmm. So I can't specifically tell you who directed it or who acted.
I just found a quote. I didn't know who it was either, but the same guy
was
produced.
Was it Charlton Heston?
Well, he was Moses.
Uh-huh.
But the narrator was Cecil DeMille. And in an interview about the movie, he said, "It's impossible for us to break the law. We can only break ourselves against the law." And so I thought that was profound, that the law doesn't change. It can't be broken.
Right.
The law is the law. And when somebody violates the law, well, they not only hurt society or the state or the victim in the case, but they're also damaging themselves.
Right.
And so you see defendants every day.
Every day.
And
multiple.
And some people might be innocent. Some people might be guilty. How do you go through that?
You know, the thing about the criminal law, which is interesting, is it's not really a black and white always situation. Every case has to be taken individually because you're looking at folks' hearts. You're looking at people in terms of what motivates them, their backgrounds, what their intentions are, the end result of whatever it is that they did in terms of the damage to society or other individuals. And so in looking at people's hearts, there's always so much more that come into play as opposed to they're guilty or they're not guilty. And I'll give you an example. I gave this example on my podcast, and to me it kind of reflects how the system works. So you have two individuals. You have one person who stole a piece of chewing gum, walking out of H-E-B, looked over at the counter and saw all the different things that are on display, grabs a piece of gum, sticks it in their pocket, and then walks out. That's a theft. It's a theft of a piece of chewing gum. You have a second individual who also steals the exact same piece of chewing gum, but this time he takes it out of a woman's purse who left it next to her unattended. And so they each committed the exact same crime, but obviously the heart of somebody that could go into somebody's purse is very different than somebody who could just take something from H-E-B or Walmart. And so those are the kind of things that you need to look at, to distinguish, to recognize who is this person. Obviously somebody who committed a theft who was young versus somebody who's older, somebody who does things for purposes that may not be as good, as ill-intended. Everything is shades of gray. And then also you have to look at what the end result is. So let's say somebody's intoxicated, they hit somebody, and that person dies, or the same person who's intoxicated in the exact same way hits somebody, that person gets injured. Well, one is an intoxication manslaughter, one is an intoxication assault. So as a result of that behavior, you have two different punishments depending on the end result. Somebody who could be even more intoxicated that doesn't hit anybody is looking at a DWI, and that punishment range is very different. So it's not only the heart, but it's also the end result and everything that goes into play with that.
Okay, well, that's a lot more philosophy than I thought that there was. I just figured that you look at the elements of the crime,
yes,
and they check these off, and that's probably the way the prosecutor presents it. but then maybe the defense paints a picture about who the defendant really was.
Right. That's
Okay.
right. That's right. And I could give you a million examples that are similar. We had a intoxication manslaughter case where a jury gave an individual defendant probation, which is always surprising because you never really think somebody who's charged with that could get probation from a jury.
Mm-hmm.
But in this case, the way the law works is if somebody is 1% responsible for the death of another as a result of their intoxication, then they're guilty. It's either not guilty or guilty. But if you look at that 1% fault, that's where you think of the punishment being different from somebody who is 100% at fault. In other words, the jury was looking at things like where the individual person who died was stopped. Their car stopped in the middle of a highway, which was very busy around the corner, which folks couldn't see. And then there were other factors involved as it related to that offense. So juries sometimes factor in somebody's guilty, but maybe they're not as guilty as 100%. And so the result of that would be a difference in sentencings.
So the jury decides guilt.
In criminal cases, both sides have a right to have a jury trial. So both the state and the defense say, we want a jury trial. They both have to waive it for there not to be a jury trial. Before the trial starts, the defense is the one who has to choose if and only if I'm found guilty by a jury, do I choose to go to the court for punishment or do I choose to go to the jury for punishment? And they
Okay.
have to make that election in writing.
Okay, so if they were very sympathetic to the jury, then that's when they might get a lighter punishment. Otherwise, it would be in the judge's hands.
It's always a risk. It's like you never know what the end result's going to be.
But there's sentencing guidelines, right?
Not on the state side. On the state side, you have a range of punishment, and they're very broad. So for a first-degree felony, think of murder, aggravated sexual assault of a child, aggravated robbery, the aggravated type cases, aggravated kidnapping. The range of punishment starts from 5 years in the penitentiary up to 99 years or life, and every single number in between.
Wow.
Lesser felonies, like a second-degree felony, has a different range of punishment. It's 2 to 20, and so that entire range is something that whoever the finder of fact would be for the sentencing could make a determination as to what is appropriate in that case.
So the jury couldn't go below the minimum.
That's correct.
Okay.
That's correct.
Well, sometimes you hear of jury nullification in civil suits, where the jury will decide something that was, decide somebody shouldn't be guilty even when it was obvious that the person was guilty, or not guilty but responsible.
Right. I don't have that experience on the civil side just because I didn't really do civil work. But on the criminal side, you don't really see that. I'm not saying it doesn't exist. I don't know. I just haven't seen that.
Okay, well, let's talk about some of the other types of cases that you would hear in your district court. You talked about family violence. Did we talk about that yet?
We talked about it before we came on the air. We were talking about the difficulties in family violence. I know that there's been some media reports lately as it relates to family violence. I did mostly family violence as a prosecutor. I handled murders, aggravated assaults, aggravated sexual assaults, things related to family violence. And those are very difficult cases to prosecute because a lot of it relates to evidence. I know that, again, you never know what a jury is going to do. Sometimes folks that read the media assume certain facts, they assume certain things are accurate, and then when they get the end result of whatever that report is, it surprises them. And that's because jury trials are always a risk. Both sides always look at jury trials as what will the end result be here if we take this before a jury. First of all, will a jury find this person guilty? On the criminal side, the Constitution provides a much higher level of proof than you do on the civil side. There's the elements that we talked about. Typically, there's 5 or more. That's the who, what, when, where, how to every criminal offense in the statute. The state's required to prove those beyond a reasonable doubt. And so what exactly does that mean? And back in the day when I was a prosecutor, we could define that for jurors. We could say beyond a reasonable doubt means X. So we can't do that anymore. Now all we can say is this is the highest level of standard of proof that exists in our law, and it must apply to these elements. So the courts and the prosecutors look at that in a way as what type of evidence would it take to prove this? Juries have to hear that. And then once juries make a determination as to whether somebody's guilty or not, if they're convicted, then they get the extra evidence that relates to punishment. And so you just never know. We're talking about 12 individuals from the community that have different backgrounds from all stages of life, different experiences. You never know what folks pick up on. So at the end of every trial, I go to the back, I communicate with the jurors, and I basically thank them. That's always my purpose. Their question to me is, do you always think we did the right thing? And I always tell them, look, you are the jury, and juries have to follow the law. So people that follow cases in the media don't have that burden of proof of beyond a reasonable doubt. To them, it's like, did this guy do it or not?
Right.
But when you give the jury instructions, this is how the law reads, this is what the law says, then they look at cases through a different lens, which is required in the law. And it's very, very often you walk away from jury process thinking that was a great jury. They really paid attention. They really focused on the things that they were supposed to focus on. And whatever end result is, that's what we consider justice.
So let's back up in the process just a little bit. So you mentioned after the trial's over, after the decision's been made, you thank them. What happens when the jury leaves the courtroom and goes to deliberate among themselves? The judge is left in the courtroom, the attorneys are left in the courtroom. Does anything happen there?
So you're talking about while the trial is going and a jury is excused, or while the jury is doing their jury deliberations?
While they're deliberating.
With that case, no. With that case, we're just waiting. But typically in the court, what we do is we bring in one of the other 600 cases that we have pending.
Oh, really?
And then we deal with those cases. So the way we schedule ours, I work in the 379th Criminal District Court. A lot of folks don't understand exactly what the numbers mean. They're basically the order in which that court was created. So the very first state court, district court in Texas was the very first court that was created on the state district court side. So this court that I work in was the 379th court that was created. It happens to be in Bexar County. We represent everybody in Bexar County. So we have up to 2,000 cases that are pending at any given time, which includes motions to revoke or adjudicate guilt, new charges, unindicted cases. And so we're always trying to fill in the gaps. So when there's a jury deliberating, then we're bringing in other cases.
You don't really wait. You just have to get some other work done.
That's exactly right.
Wow.
That's exactly right.
And one thing I heard on your podcast was you explaining how all of the Bexar County district courts have the same jurisdiction. You share the jurisdiction.
That's exactly right.
And so how are the cases assigned?
So there are 10 criminal district courts. There are 10 courts that handle felony cases in all of Bexar County. And so every 10th arrest falls into the court that I work for, that I work in. So it just goes in order. If there is a case then that it's not a recusal issue, but maybe the appearance may not look appropriate, then any of the other 9 could handle that case. Because we all share that same jurisdiction. Sometimes, we have to do that. Sometimes we think I'm not recused, but just to maintain the appearance of justice, I'll let another court handle this.
Okay. You've heard it here on Talk Law Radio with Honorable Judge Rangel. We've been talking about district court, and we've been talking about felonies for the most part. When we come back, we'll be talking about sinners and saints, and we'll continue talking about the criminal justice system. Stay tuned.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.